What's up? 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 What's happening? Boom. How y'all doing? How y'all doing? How's your day? Everything good? Good, 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 good. You know what time it is. We got to go at this one more time. One more time. This one we're going to use US 42. We're going to use US 42. Real quick. We're going to go right into it where it says US 42 Code subsection 1983, civil actions for the deprivation of a right, which is really a right or a privilege, right? So we're gonna move forward and we're gonna go to let's talk about the incident. Let's talk about the incident. We already know about that. We're gonna get into that in a minute. Let's talk about the incident. All right. The incident goes to that 40 Rector experience and their outcome and their decision. So you got down here on the bottom, where we're going to go to where it says, under US 42, it says, except that in any actions brought against a judicial officer for act or omission taken in such officer's judicial capacity. Got to understand that. So we're going to go back to the administrative law judge and his decision. Now, remember, in this key thing, this case was loaded with a number of improprieties. And in Judge's Code of Professionalism Responsibility, we're going to go to canons number 2. Canons number 1 is the integrity. You can't violate your integrity, okay, as a judge. So on canons number 2 is that judges are to avoid impropriety and even the appearance of an impropriety. So we could hit it real hard on the improprieties where the sergeant kicked out her orders before the officer started, but she failed to send transportation. The other sergeant, he wrote the officer up 2 days later in his memo book, which wasn't in chronological order. Those are improprieties. I don't want to hear about your burden of proof and then your preponderance of evidence. You must do it the right way. If you don't follow your due process under your policies and procedures, and that if you ain't following your procedures in the whole 9 yards, I don't want to hear it. That's thrown out. That's a violation of due process. And you know when you violate due process under your 5th or 14th Amendment, we're not even going to stay on that straw man side. Oh, no, we're not going to go on the public side. We're going to go on the private side. When we go on the private side, we're going to bring in that substantial right and that substantive right of due process. Okay? Now, moving forward, we're going to go back to Jackie Robinson. Basically where it says that every person who's under a color of any statute, ordinance, or regulation, or uses of any state or territory of the District of Columbia, subject or caused to be subject, any citizen of the United States or other person within the jurisdiction thereof to the deprivation of any rights, privileges, or immunities secured by the Constitution and laws shall be liable to the parties injured in an action of lawsuit in equity or the proper proceeding for redress. Okay, so like they got to do, if there's a proper proceeding for that, proper proceeding is basically corrective actions. Okay, that's what that is, corrective actions. Now, it comes down here, it says, except that in any action brought against a judicial officer for an act or a omission taken in subset officer's judicial capacity in the scope of their job, right? Injunctive relief shall not be granted unless a declaratory decree was violated or declaratory relief was unavailable. Now you got to understand what that declaratory decree decree, all right? So what is the declaratory? What is that? What you basically saying? So on that note, you gotta go and do your research. So I did my research, and in doing my research, we bring up declarations law. The authoritative establishment of a fact by a court of law. In law, the declaration is an authoritative establishment of a fact. Declaration takes various forms of different legal systems. Okay, and it comes right down to what? It's backwards. I know you can see it, but it's right there. Oh, come on back. Ooh, it's right there. When it comes right there, it's basically saying common law. No, canon's law. Canon's law, such as the judge's canon, such as the lawyer's canon. In canon's law, it says main article, declaration is a nullity. In the canon law of the Catholic Church, a declaration of a nullity, and it says commonly called an annulment, and less commonly a decree of nullity, is authorization, right? Authoritative judgment on the part of tribunal established for the fact that a marriage, right, is a marriage was invalid contract, or less frequent, a judgment, jurisdictional establishment that the fact that a ordination was invalid conferred. It does not mean dissolve a valid bond of the marriage, but it merely means a factual declaration of the nullity of the bond. All right. What up, bro? Let me give you that wave. All right. Got Clark Pena on the line. All right. So basically, with that, it'll come down to the common law. But we're gonna stick to the facts. The facts is the mere fact that the judge did that, he lost his immunity. And if you think I'm playing, you're going to go to the Black's Law Dictionary, where it says nullity. Properly, that which does not exist. That which is not properly in the nature of things. See, in the nature of things, it would go to your natural side. The live person, that's twice the strength of the straw man side, which is the public side, which is the, your straw man, the fictitious person side, right? All capitals. And it says, in a figurative sense and in law, it means that which has no effect than it did not exist. Okay? And also that a defect was which presents it from having such effects. That which is absolutely voided. It says it on the bottom right there. Absolutely voided. So basically it's saying that under their nullity and that they lost their, how would you say, immunity. You got to understand this and that. So when they try to bring you upstairs and bring you on this fraudulent stuff, then even try to bring you down to 40 rector, and they got these, like I said, the lawyers and them, they're in a different game because they're in the well. As they're in the well of the ship and all that, because a court is a ship. The tribunal is a ship. The judge is the ordinary person that's sitting up top. Supposed to be the standing person. He's just an ordinary person that's sitting on the top. All right? But you got the two lawyers and they doing this dance. You got to make sure that your lawyer is representing you properly under his fiduciary. Do your homework under his fiduciary. such as your representing union, when they send these people down there to represent you and they don't know what they're talking about. How are you coming down here and you don't know what you don't know what you're talking about? What is your fiduciary? What is my contract? You know what I'm saying? How are you gonna guard me under my contract, under my signed contract agreement? They ain't there getting in bed with management, and management is like, yo, we just gonna get rid of this dude, or we gonna get rid of this person. We gonna do what we gonna do. Okay, you can do what you want to do. It's not a problem. You know what I'm saying? You want to open a corporation up to a lawsuit? Not a problem. Because no matter what you say, when you deprive that person of that right and privilege in the whole 9 yards, it's going to always come back to that Jackie Robinson, that U.S. Code 42. Why? Because there's no statute of limitations on that. See, when you would go to 242 when it's a governmental entity going after another governmental entity. That'll be on that level. But on the 42, you're allowed to go after them yourself. So basically, just sit back, do your homework. As long as you do your homework in the whole 9 yards, grab all your information. Grab all your information. When you grab all your information in the whole 9 yards, then you could go at them on the attack. You could take from there, take a good run, and go at them. Because the key thing is, it's representation. This is something you pay for. It comes out of your union dues. This is something you pay for. Don't get it twisted. It's something you pay for. All right? Like I always say, download your corporate compliance policy. As long as you know your corporate compliance policy, you know what you're governed to do under your employer. You know what you have to do. Download your signed contract agreement. As long as you know what's in your signed contract agreement in the whole 9 yards, you can hold that against your representatives under your union, where they send these lawyers out. I mean, the lawyer that came out with me when I went to Teamsters Union at brother Vic Ash is there. How you doing, Vic? How you doing? All right. When I went to Local 237 and the grievance coordinator Todd Rubenstein, I'd say it, and the first thing he said to me, is like, oh, if he don't want you, if your director don't want you there, he could get rid of you. He could let you go. Really? Like, this is somebody who's getting paid to represent you. And you are a permanent employee. You are vested. You're past 5 years. You are vested. You don't have a troublesome background. They try to build up a troublesome background. And then when you find out that the folder that they built up is loaded with lies, like, how you going to do this? If you want to do this, if I'm a supervisor, and I want to pull out fraudulent, like my man here, I want to pull out fraudulent documents and file these on the record, I want you to understand this. One document filed on the record, such as that sergeant, one document. Oh, I'm writing them up. So you make it a punishable instrument. Yeah. You do know you're a public servant. Yeah. You do know your powers. Yes. Okay, as a public servant, and you're going to do this, what constitutes official misconduct, 19500. But you're going to go ahead and write this punishable statement. Because when you first write it, it's just a statement. So you write it up. It's a statement. The mere fact that you're writing a punishable statement with false written information. Now we're moving up to 21045, which is a class A misdemeanor. So you're up to 2 of them right there. That's 2 of them. Now you're going to take this and you're going to file it on the record. This same document. When you file this same document on the record, now we're moving up to 17530. Which is also a Class A misdemeanor. So you're now up to 3. Did you think about the fact that you work for a corporation? That would bring in 2020 under criminal liability. 4, you're a supervisor for that corporation. All right? That still would fall under 2025. We up to 5. Now, 5, right? That's 5 laws bro. Did you violate due process in that? What do we do when we get people that violate due process? What is that what we do? When we write them up. They come in and they violate due process. They're violating the procedures. They violate policies. Okay, when we get them with that, isn't that a obstruction of governmental administration? Because there's a procedure you're supposed to follow. And if you're not following that procedure, that would be obstruction of governmental administration. You better figure it out. That too is a Class A misdemeanor. So we up to 6. We up to 6 right there. All right. Now, moving forward, is you gonna file this with on the record and with any other entity? Yeah. To file this with any other entity, such as any governmental entity, what constitutes violation of Penal Law Code 496.02? That's a Class E felony. That's a felony. So you just took this and filed it there, and I'm gonna go get this guy for his job, and you just threw your job right out the window. Pay attention to what you're doing. Pay attention. No one does what I do or what I'm doing for this length of time to expose what they did in their actions of corruption. No one does this on this level. I love the fact that you made me do this. It's not just for you, but it's also for another city agency. The fact of me not just being a law enforcement officer and being able to, function in doing what it is, what we do as far as the law enforcement, but the mere fact that understanding what it is we do and how we use it when we writing up these documents and submitting these documents on the record. So it's not that hard to go study law in the whole 9 yards and then get it from there and then, find out all these things that they violate. Now, like I said, the litigation's attorney, he knew. He knew. But yet, when we get to 40 Rector, he walks through the door and he's telling the opposing attorney, which is the attorney for Health and Hospitals, he's telling her, you got this. In the presence of others. This is so sweet because when you go to 40 Rector, you get the bubbles all over and it shows you walking right up to her and you're telling her. What makes it even worse is the receptionist who you must check in when you first come in. You made her get up out of her seat and she came out from her station and came to you while you was there telling Health and Hospitals attorney and supervision, you got this. She came and told you, yo, your client's over there. He's over there. So your actions were deceptive right there. It's your deceptive practices. And you open up Teamsters right there by depriving me of my right. Civil Service Law, Section 75B. Under all of this stuff that was done, you were supposed to throw that case out. There was no way in the world a judge was supposed to even try to hear this case. Why? Because of the whistleblower that was in place. Because of the whistleblowers in place. And if you don't understand, let's go to the simple fact. You had me go upstairs to labor relations on March 31st, 2009? The EEO said that in her rebuttal that she scheduled a meeting for April 6th. The meeting was supposed to be based on corrective and preventive actions of conflict resolution within the workplace. This dates all the way back to July 17th, 2008, where the probationary employee used his vehicle in a reckless endangerment manner on Health and Hospitals property, which would be city property. So you can delay the fact all you want. There's too many cameras there that shows that. There's too many cameras. And the cameras, no more videotape, it's a digital file. And then how many times does a person walk by and just take one of these and videotape you and take pictures? And look. This is how I definitely get the wheels to blow. When they returned that night, Old boy told them, don't let them down there at the park. On the signed contract agreement, you're going to violate my signed contract agreement? Yeah. So you're going to deprive me of a right. Wouldn't that be U.S. Code 42? This is so ugly, yo. And it's sweet. Why? How many people have you done this to? That's the key. That's why I keep doing it. How many people have you done this to? You won't be doing this for long. Matter of fact, two sergeants who took the sergeant exam with me, we all passed. They got made. After, I would say, 2016, around October, late September, October, might even been early November, in the fall. They got called in to classes for corporate compliance. Yeah, they went to corporate compliance training. Why? Think about it. Right after that, Clark Pena. Yeah, Clark. Before that, that was June. Clark sent me that buzz. Yo, old boy just got terminated. Remember that, Clark? I got that late that afternoon. I got upstairs where I was at, and one of those sergeants contacted me. And he said, as soon as he get off the clock, he's coming there. And when he got there, he said, what happened today? And I tried to hide it from him. He already knew. He's with a different agency. Both of those two sergeants were different agencies. He already knew. He said, what happened today? And I tried to play it off and said, nothing happened today, nothing happened. And he's like, oh, really? He just sat there. Then I said, nah, old boy resigned. He said, no, he didn't. He got fired. Then I later learned from other Division 19 officers, he got walked out the front door. Key thing is why it took so long. I really don't care. You have your own corporate compliance policy under, what is that? Personnel rules and regulations that's registered with the state of New York. And we're going to go to 5.2.3 under probationary employee. And the mere fact that this individual used this vehicle in threatening matters against 3 people on 3 separate incidents. 3 separate. All right? So that would be gross misconduct, right? And under 5.2.3, a temporary employee or probationary employee is supposed to be terminated effective immediately for a violation of gross misconduct. But you let it slide all the way up where we're going to 40 rector and the whole 9 yards. Why you think I wanted to go to 40 rector? So you could put it on the record. So they now have that case on the record as far as case law. And it's a fraudulent case. From the judge and the lawyers on down. Sweet! Sweet! Any questions? Any questions? I see y'all there, man. Come on, man. Holler at me. Get at me. Come on, why don't you jump in? Clark, why don't you jump in, baby? Come on and jump in. I see you still watching. Why don't you jump in? How about you, Vic? Why don't you jump in? Anybody, jump in. Must be doing something right. Must be doing something right. Now moving forward. I don't know. I'm going to jump out of this one. I got to get another one in. You know what I'm saying? I'll be back. Because I got another agency. Well, we're going to go right on into it. Got another city agency who is issuing summonses. Right? They issuing these summonses And the summonses they issuing, how you going to issue to, you got property A and property B. The only way you could get on property B is you must come through property A. How are you issuing summonses to property B without issuing in conjunction with property A? You did mess up. You got one summons that says in conjunction with property A. This brings about that question about those 50 building inspectors for bribery. What was that, 2015? They were caught? But let's go to the 16. Sweet 16. The 16 is the Department of Building employees that was caught up in that bribery. And 2 of them were borough chiefs. Or bureau chiefs, however. All right? And you got these individuals who wrote these fraudulent summonses. And then they wrote 2. How you going to write? Let me go there. They ran up in the house. They found the uniforms and the whole 9 yards and tried to say they stole them. And the 8-3 captain was like, are you kidding me? You see the size of the uniforms? Yeah. You see the size of the owner? Yeah. I don't think he stole them. Love that 8-3 captain. He real cool. He came right out the door, shook his head, looking up in the sky, and looking at us as I'm standing with other first responders, went right to his officer, said, do you know this guy? And they said, yeah, that's that Woodhall cop. He's a Woodhall cop. Came over, officer, you on the job? And I said, well, yeah, but I'm going through some nonsense at the time. And he's like, I said, yes, Cap. And he said, this guy just found your uniforms, tried to say that you stole them. He said, the uniforms are on every floor. Had all of us hollering. So what happened to the buildings guy? He's standing on the top of the steps. Let's go there. That injury wouldn't occur if Department of Buildings would have did their jobs by issuing Lot A or Property A summonses for the illegal activity. So you trying to cover up your gross negligence? That's gross negligence because you didn't do what you were supposed to do on the signed contract by issuing them summonses. Why? Wouldn't that be subsection 182, self-service storage facility? Wouldn't that be that? Will you put a lien on them? No, but you let them operate in the whole 9 yards, and he's putting the vehicles next to my home, which caused it to sink, which threw off the foundation, which caused the house to pitch, throwing off the foundation, which caused the chimney to come down. Yeah, baby, that's it. Yeah. But then you're going to try to double back and write summonses for that same individual who's parking the vehicles on my property. You're going to write me these summonses? I'm going to hang you with these summonses. The mere fact you failed to do what you're supposed to do will bring about gross negligence. The mere fact that you took and you wrote the summonses to me, that would be gross misconduct. And under that gross misconduct, we would bring about, what's that? Breach of duty? Yeah. Breach of duty, which brings about an omission. Yeah, something that you failed to do that you're supposed to do by law under that breach of duty. And the mere fact that you're writing those summonses in there, would that be a crime of omission? Yeah, because you was supposed to do that by law, and you writing the summonses to me, right? Yeah, let's go further under that crime of omission. Let's go there. You caused the injury, right? Caused me to be an injury. And an injury is an act or omission. The omission is something that you failed to do. Now let's bring it to those summonses for each one that you wrote after you violate your corporate compliance policy. The first one you wrote, which is a punishable instrument, will fall under 21045. You get a punishable statement because you wrote it up. Then you submitted it for the record. 175:30. Another class A misdemeanor. Do I got to go down the same line? If you wrote it up again, it's 175.35. It's a Class E felony. When I come back, I'm going to come back with the list of all your, let's say, Operation ID numbers that you put on your summons. And on that note, you know the deal. The facts cannot be altered nor denied. Y'all have a wonderful day, and I'm out.